Attorney Garcia, do you need to speak with the DAs?
I do, Judge.
All right. Can we put the Attorney Garcia in with the conferring DA, who is conferring DA, ADA? Mr. Bosis, Attorney Han Martinez, who's conferring?
I think, Judge, right now, if Ms. Han could confer, that would be good.
Okay. All right, let's go ahead and put ADA Garcia in, Attorney Garcia in with ADA Han Martinez.
Thank you.
All right. So, Attorney Hayek, are we trying to do a plea on this?
I believe the plea is set for a little bit down the road, and I've forgotten why. I think she's applied for PTD. She may have been accepted. Elizabeth, do you remember if you've been accepted to PTD?
This is set for a plea, sir. It's set for a plea, and I needed the paperwork on the 1st. You're supposed to get the paperwork on the 31st, and I'm getting the paperwork on the 1st, which was 2 days ago. So, and I don't have the paperwork. So you want to talk to ADAs and find out where the paperwork is?
All right.
All righty. I'll go ahead. ADA Bosis, will he talk to you, or can he would Han Martinez be able to find that paperwork for him?
No, he can talk to me, Judge, because I sent out the paperwork.
Okay. Then you know where it's at? On cause number 630032, sir.
It shows as being with Ms. Barnes right now. I can discuss with Mr. Hayek to make sure I have the right email address for her.
Okay. Let's go ahead and get the three of you in a quick breakout to go ahead and figure all that out, and then count, as you know, ADA, I need you right back so that we can do the motion for continuance, okay?
Okay.
All righty, thank you so much. All right, let's get him. Mr. Hayek can go in with, Attorney Hayek can go in, and, okay, she's got, you should have your invitation, sir. Attorney Hayek, you should have your invitation. Attorney George.
Good afternoon, Judge.
Good afternoon. I want to find out how much you could have made. Could you have retired as a billionaire by now for the number of people who call you Dylan?
Maybe just a millionaire, Judge. I had $1 every time.
Right? It's I even looking at your names, okay, I have to concentrate and go, no, it's Attorney George, it's not Attorney Dylan. Okay, and then he's coming, this one's coming. Okay. Okay, I believe Attorney Harm Martinez, are you going to do the motion for continuance? Are you going to argue it, or is Attorney ADA Bosis? You're muted.
Judge, we have not discussed who would be arguing that motion. I imagine that he probably will, and
Okay.
I'm happy to,
All right, let me. Okay, counsel, Attorney Garcia, and we'll just wait for Attorney George. We're just gonna wait for ADA Bosis. Attorney Garcia, we have got your client. Were you able to get a hold of your client? Is she showing up?
Well, she texted me this morning, Judge, and so I texted her the Zoom link and told her to be here at 1. Is she not on Zoom?
I'm not seeing her. Are you? I don't see anybody in the waiting room.
Okay. Looking at the participant list, and there's nothing with her name on it. Let me try calling her, Judge. I think we've worked out a possible deal of PTD, but I need to confirm it with her. But she also
Okay.
needs to show up. So let me see if I can get her.
Okay, and you know there is an Article 16.22 of the Texas Code of Criminal Procedure report associated with your client and all her cases?
No, I didn't know that, Judge.
Right. That red envelope?
All right, I'll look into that.
ADA Han Martinez, can you see if that's available and has been placed in e-discovery for defense?
for the 16.22.
Yes, it's a Tacomi report. It actually looks somewhat like this. Let's get all the other cases pulled on this person.
Okay.
'Cause I have 614-051, please. 614-051. They may the other two may be taken care of. Just if you double check.
It shows that this is the only.
One? Okay. Okay. Attorney Garcia, what do you want to do? Do you want to go ahead and we just wait because we'll be here?
Judge, I've got her on the phone, so she just got out of work, so she'll be jumping on shortly.
Great, that'll work.
Thanks.
Judge, I don't see a 16.22 form in our discovery.
You don't have it?
No, Judge, I do not see it. It is quite possible I'm running the search incorrectly. I'm sorry.
Attorney Garcia, it's in the court file. If you can stop on by, make that available to you. It is in the court file. It's in a red envelope and you have access to it. Okay, sir?
Actually, Judge, she'll be jumping on. Autumn Bieniek will be jumping on right now, and I've conferred with her about the PTD. I think actually we're gonna need a trial setting, Judge, and that'll give me time to stop by and take a look at that notice.
Okay. Were you guys thinking about a PTD? Okay, while I didn't notice that Attorney Bosis was back. So while we're waiting there, let's get on record. Attorney we're looking at clause number 680152, State of Texas versus Gilbert Tijerina. Attorneys, parties, please approach and identify who is before the court, starting with the state.
Brett Bosis for the state.
Bill and George for the defense.
And are you Mr. Gilbert Tijerina? Let the record reflect that the defendant is physically in the courtroom and in this session with his attorney, albeit the attorney is via Zoom. Sir, do you have any problems hearing anything that's going on with the proceedings? No. All righty, you may have a seat, okay? All righty, so we're here, I believe, to examine the state's first motion for continuance. State, your motion, please proceed.
Thank you, Judge. So I'll keep things relatively brief. State's first argument is that this case, for a reason unknown to me, did not make it onto the court's docket. According to your notes, we had a PTC, and at that point in time, it was decided that June 2nd would be the trial announcement date. However, that was then not reflected in any of the electronic records of the court in the CJIS system, and it also was not reflected on the docket. The state relies on CJIS and relies on the court's dockets to prepare for each day of court. And because this case was somehow missed, we were not able to adequately prepare. And that is why we had to announce not ready for trial. And our second argument is that regardless, the incident date from this case is March 1st of 2022. So we're talking about a case that is 3 months and 2 days old as of today. And while I certainly do not wish to impinge on the defendant's right to a speedy trial in any way, there would be no prejudice to the defendant whatsoever were the court to grant the state a short reset of 2 weeks to 30 days, whatever the court sees fit, to have time to prepare and gather its witnesses. I mean, even with that reset, we'd be talking about a trial taking place 4 months after the incident date. And so there'd be no concern about speedy trial issues or prejudice to the defendant or anything like that. This is our first trial setting. Neither party has requested a continuance before. And so for all these reasons, we think it's a reasonable request to have a short continuance and give the state a proper chance to prepare for trial. And so that's why we would ask the court to grant our first motion for continuance.
Defense?
Your Honor, as the court noted yesterday, and I believe this court is actually very strict in its formalities and making sure that everyone knows exactly what's going on. And when dates are set, everyone knows it. And also, as the court noted, the docket notes from that day are in the court's file, available to both sides. We announced June 6th, it was agreed to, and defense is ready to move forward.
State rebuttal?
Judge, the only thing I would add is that this is a theft case, and so there is a complainant in this type of case, and whether it be the state's mistake for not keeping track of the dates or regardless of why the case slipped through the cracks and didn't get on the docket, if the court denies the state's motion and the state is forced to dismiss, well, the point is that the complainant should also have an opportunity to have their testimony heard by the court, and the state hasn't had an opportunity to reach out to them because of the reasons I mentioned before. And so we would just add that as one more reason to grant a short reset and just give us the opportunity and give the complainant an opportunity to be ready for trial.
Defense, you have anything further?
No, Your Honor.
State, anything further on this matter?
No, nothing further from the state.
For clarity and discussion, the court was want to go ahead and assist with an understanding regarding this matter. Since its inception of my administration in this court, this pretrial conference hearing was established almost immediately for that particular purpose, as the defense has pointed out, so that we iron a lot of matters out and be able to set dates with agreements by the attorneys of the parties that are involved. The judge's notes are prepared and they are in the court file. Several times I send out reminders or state reminders that those judge's notes are in the file. Both the state and the defense can get copies of that as far as reminders to be able to know what they have, reminders as far as what they have agreed to, what the dates are. In preparation for those pretrial conferences, this court initiated allowing the state at least a day before to be able to prepare for those pretrial conference hearings, and has set the court schedule so that the state does have that opportunity on Wednesdays to be able to reach out to their witnesses in preparation for, so that they will be prepared to make reasonable, to negotiate with the defense on the matter. The pretrial conference hearings are set defense by the defense with the defense's schedule, in consideration of the defense's schedule, and that is noted. And so the state basically give up to 4 months for the defense, so that folks will have opportunity to be able to prepare for these cases. The trial announcement is made on record. Those trial dates are set. The state agrees to those trial dates. The state has its files to be able to go ahead and note those trial dates. This court has tried to engage the state to ensure, if you have, to make sure there's a review to be able to go over and say these matters are set for trial, just logistically to make sure, as far as reviewing the docket, just to make sure that they are, that we're in sync as far as the docket is concerned. The state has been reluctant in doing that, has stated that they're uncomfortable in doing that, yet they keep bringing up the fact as far as issues with that. Matters not being on the docket. So at this time, with that understanding, state you had an opportunity. We'll see you on Tuesday for this matter to go to trial. Your motion for continuance is denied. This court, because of the way the court schedules, I try to minimize continuances because we wish to be able to give the defendant the day in court as soon as possible. State so that we will be able to make sure, I think Mr. Tijerina has come to this court, at least has made every court setting and has come in person. And those expenses that has incurred and the time that he has spent in court, I think those things need to also be considered. So state's motion for continuance is denied. We'll see you Tuesday morning at 11 o'clock. We can go ahead and see who's going to go to trial. I do have another case set for trial. Okay.
Yes, Your Honor.
All right. Furthermore, the reason I have trial settings on trial announcements on Thursday, it gives an opportunity, and I deliberately spoke, I have chosen for trials to start for me to get juries in the afternoon of Tuesday, as we're metering them out and scheduling them. So that gives at least 2 good days, 2.5 days to be prepared, for people to go ahead and do their final preparations for trial. All righty. So see you on Tuesday.
Yes, sir.
You guys have indicated that this will probably be a trial that might last 1.5 days. Again, I'll see you about 11. The jury should be here around about 12:30, 1 o'clock, and we'll go ahead and get started immediately to voir dire. Each side gets 30 minutes for general and specific voir dire. Opening and closing statements, 15 minutes each side. And the same with closing arguments, each side. If there are any pretrial matters, please let's hear them tomorrow, or today is Friday. Let's hear them on Monday if there are any pretrial matters. Any other questions, come early and we'll figure out that as far as the logistics are concerned. All right.
Yes, sir.
Thank you.
Thank you, Judge.
Just wait for your reset, okay, sir? We're off record on the matter. Just wait for your reset and see you on Tuesday, okay? All righty, sir. Counsel, anything further? I think he's gone already. Okay. All righty. Is Miss Bianek, is she? Oh, okay, she has shown up.
Yes,
All right.
Judge, she's under Autumn.
All righty. I need first name and last name, please, and a video.
I'm right here.
Very good. I need first name and last name. I don't need hearts. I need for your name to display first name and last name. And I need for you to stop chewing gum. Let me put you in with the deputy. All right, what's the status with Barnes? Counsel, I also sent you an invitation for you and your client. to talk to the deputy, okay? What's happening with Barnes? Do we have the cause number 6300032? ADA BOSIS, are they working on the plea?
I assume they're still in the breakout room. I haven't seen them back in here yet.
Is it that they had the defendant, the plea paperwork was with the defendant?
Yes, yeah, the plea paperwork is with her.
Okay. State, you have, you say you guys have a mandatory CLE. Is that going to be all afternoon for the rest of the afternoon?
I believe it's,
Judge, I think it's 1 hour.
Alrighty. Well, if they're not back, please go ahead and feel free to go. And then see if you can come back around about 3:30 or soon thereafter, if they have their document ready. If not, I'll be more than glad to recall them for Monday or so to do it. I was supposed to get the paperwork 2 days ago.
okay, Judge, we'll check back at 3:30.
And the attorneys need to be following up with you guys. They agreed, they asked you to go ahead and send it a certain date. If they need to be following up, that's why they asked for those dates. They need to be following up with you, so. Okay, alrighty, so if they're not back, please feel free to go and come back at 3:30. I'll tell them to come back at that time. You let me know when you guys will be coming back. I'll tell them to come back at that time, okay? On Barnes.
Okay,
Okay, are we ready? Now, Ms. Bianek or Bianek, how do you pronounce your name correctly? Okay, Counsel Attorney Garcia, how is that pronounced correctly, last name?
I believe it's Bieniek, Judge.
Bianek, is your head about to fall off, Miss Bianek?
No,
Alrighty, let's go ahead and sit up then, please. You are in court.
I am sitting up. I was just looking at.
You can
Texan.
remove your hand from your face, ma'am. Sit up. Thank you. All right, counsel, what are we going to do with this case?
I think we need to be put on a trial docket, Judge.
You ready? Okay. State, are you ready to do a pretrial conference hearing at this time, or do we need to set it for pretrial conference? We need to give you some time for pretrial conference. It's not, it's.
I mean, I think we could probably just do it now.
Okay, if you guys are ready, let's go ahead and do that. All right, let's get on record on cause number 614-051, State of Texas versus Autumn Faith Bianek. Attorneys and attorneys only, please approach and identify who's before the court, starting with the state.
Brett Moses for the state.
David A. Garcia, attorney for Autumn Bieniek, Judge.
And we're here for pretrial conference hearing. State, proceed, please.
This is a case from the Bear County Sheriff's Office. We have conveyed an offer to defense for pretrial diversion at this time.
You have found this case and this defendant eligible for pretrial diversion.
Yes, we have approved it for her to apply for pretrial diversion.
Okay. Defense, do you acknowledge receipt of the offer conveyed for pretrial diversion and that matter was conveyed to you in writing from the state?
Not in writing, Judge, but they told me about it and we declined it.
Okay. Okay. All right, how are we going to dispose of this matter? Defense?
If you can just put us on a trial setting, Judge.
All righty,
I'll
would you
offer.
please go ahead and consult your calendar. Trial announcements are Thursdays. It will become Thursday mornings and we can spill it to afternoon the trial is set for Mondays, even though we may have a jury coming in later, but the trial is set for Monday. So if you could consult your calendar for that.
What month, Judge?
Soon as you wish to go ahead and dispose of this case, but we're not going out beyond 4 months, sir. This is a 2019 case, so I'd like to see it disposed of sooner than later.
How about coming back? You want us to come back on a Thursday, Judge, or a Monday?
Well, the trial announcement is going to be on a Thursday. The defendant must be present, and then the trial is actually set on a Monday date.
All right, why don't we come back Thursday, October 6th?
That's too far out, sir. This is a
Right.
2019 case.
Right, I'm just trying to set it so that I'm ahead of the game before all the felonies. So if you want me to look at September, let's do.
It's a 2019 case, sir. I'm looking at something if we can do that within the next month.
We can set it, Judge. I'm just saying, with all the felony cases I've got set for trial, I usually have like 4 felony cases set every trial, every week. Obviously, not every one of them goes, but let's see here. I'm going to be out of town the last 2 weeks of July, so you're probably better off in August, Judge. You want to do August 4th?
So again, this is a 2019 case.
I understand, Judge.
Yes. 2021, we're looking at 3 years old already. We
Right.
need to go ahead and dispose of it sooner than later.
Good.
Then, Judge, why don't we just, let's see, today's the 3rd. Why don't we set it for the 9th? And we'll set it for next week, and then we'll try it on the 13th if I'm free.
And I understand that felonies do take precedence over misdemeanor courts, sir, but this will probably be a short setting for you because it is pretty old. It's a 3-year-old case, so we're probably gonna go.
I mean, that's fine, Judge. I just want you to understand that, you know, I'll tell all of my courts and all of the judges, and you guys can argue amongst yourselves. I'm just a pawn in this game, Judge. You guys make the decision, but I
Okay,
leave that to you guys.
all righty. So
Judge,
what
if
looks best?
defense,
Yeah.
Judge, if defense is telling the court that he's booked up on trial dates, then the state doesn't want to set it for trial and prepare next week if the likely outcome is that he's going to be occupied in one of the district courts. It doesn't make sense. This case should be set for a time when defense will be available and ready to go to trial. So that way time isn't wasted preparing a case that's not going to go.
And it appears that a lot of things don't make sense to you, Mr. Bosis, but and I appreciate your input. Attorney Garcia, what date, looking at your calendar, is reasonable? And really, we need to go ahead and take care of this sooner than later. I'm
Right, Judge.
looking.
But what month are we talking about? Are we talking about this month, next month, August, or September? Pick a month, Judge.
This month or July?
Like I said, July is going to be bad, Judge, because I'm going to be gone the last 2 weeks. And if any of those felonies go to trial, that's going to be cutting it close as it is. I don't want to throw this in the mix and have that problem.
Not a problem, sir. We can go ahead and be coming back on this one until we go to trial. So,
All right,
well, then
let's just set it for next week, Judge.
All right, state.
State objects, but I'm going to get overruled anyway.
All righty. Defense, second date.
Excuse me?
Second date. Defense says, hey, next week is too soon for them. They get one objection.
Okay, well
If
then,
defense is, my apologies. If defense is saying that next week is the best week in June that they have, then I will not object to
no,
that.
I'm not, I'm saying I don't have a good week at all in June.
Hang on 2 seconds. What I'm going to do is I'm going to suspend the record right now because we are on record and my court coordinator has to do all that typing. As I have done with folks here in person, I'm going to put you guys in a breakout room, come up with the date, look at your calendars, June, July, to be able to dispose of this matter by trial.
Judge, I don't think that's necessary. I think we should just set it and just move forward.
I'm going to suspend the record at this time. Please get it in a breakout room. You should have, let me move you to a breakout room and you guys come to a date that you both can agree on.
In what month, Judge?
June or July. Okay, Mr. Bosis, I put him in the breakout room with you. You should still have access to your breakout room.
On this one, we have 7 and 6. It's been Monday, right? Just want to clarify.
Yeah, he's coming back on Monday.
Okay, I just saw.
No,
7.
2. Oh, no, 7. Yeah, just trying.
So Tuesday.
Yeah, Tuesday he needs to come back. Thank you. Do you see the paperwork for Barnes?
Or I'm sorry.
Yeah, Barnes. 630. So State, would it be, what time will you be able to come back? 3:15 or 3:30? Which one would be better for you? 3:15 or 3:30? 3:30? To take the plea?
I think 3:15 would be easier because it's just a 1 hour CLE so far as I can tell.
Have you? Okay, I haven't quite received the paperwork for Barnes, so we'll go ahead and come back at 3:30, 3:15. State.
Judge, I apologize. I'm scheduled for work at 4 o'clock.
Should have had the paperwork into me by the 1st of June. All righty, so talk to your attorney. So see you back at 3:15. By that time, I should have the paperwork. Okay. Are we ready to get back on record on cause number 614-051 on Bianek?
We are, Judge.
BNEC, I'm sorry, BNEC, I'm sorry.
BNX, fine.
BNEC, thank you. All righty, let's get back on record on cause number 614-051, State of Texas versus Autumn Faith BNEC. At the time that we suspended the record, the state and the defense needed to confer to decide on a trial date. The state had proffered, indicated that they had provided, have found this case and this defendant to be eligible for pretrial diversion, and that was declined. So we're going to dispose of this matter by trial. What's the trial date?
Well, the pretrial date, I believe, is the 16th, and then I guess we would start on the 20th, Judge.
Okay, so trial announcement, 16 June.
And Judge, will that be by Zoom or in person?
Oh, trial announcement is by Zoom, can be by Zoom. The defendant must be present. And then trial on the 20th?
Yes.
Okay. State?
Yes, we talked with defense and we're in agreement with those dates.
Alrighty. Will an interpreter be needed for the defendant?
No, Judge.
Regarding witnesses, will the defense rely on the state's file and police reports, file a motion, or have the witnesses read on record at this time?
We'll rely on the state's open file discovery, Judge.
All right. State, you reserve your right to supplement?
No, Judge, there won't be any need for supplementation.
All motions and pretrial requests will be in writing. State, have you filed any motions in this case?
No.
Defense?
No, Judge, but I will file them and they can run with the trial.
All righty. Because of the scheduling that I have with, as far as the trial is concerned, sir, if there's going to be any motions that the court needs to arbitrate on, then we need to go ahead and set them for a Friday, hearing on a Friday. I don't run motions with pretrial motions with the trial.
Okay, well, I'll file them, and if there's something that needs to be done before, we'll do it on that Friday.
All right, sir. Thank you. State, Do you have any discovery issues or concerns?
None that I'm aware of.
Defense?
I've just looked at what's on the Veripic, Judge, and there's like one report. I don't know if there's Coban or body cam that should be coming with this. I'll bring that up to the DA after I look through everything to prepare for the trial.
State, regarding body cam or Coban or any kind of videos, is there any such associated with this case that you know of and or can address?
I can't address specifics, but I will request any and all video associated with this case from the Bexar County Sheriff's Office.
And State, when would you be able to go ahead and do that?
I'll send the email requesting that today.
Counsel, you've received your e-discovery?
I looked at it today as far as what I have requested, Judge. I don't foresee a problem. It's just that, it is a simple case, but usually there are there's video attached usually. So I'll work with Mr. Bosis to make sure that we get everything.
Alrighty, and so you have received your e-discovery. What about the information, sir?
I do not have a copy of the information, Judge. We never get those ahead of time.
Okay, you know it's available through the county clerk.
Right. Well, I've run into instances where I've asked the clerks and they've asked me to go to the county clerk office as opposed to your clerk's, Judge. But either way, I'll get it.
And sir, we do have the court file here as well. It's in the court file, along with the 1622 report that's associated, Article 1622 of the Texas Code of Criminal Procedure, report that's associated with your client, if you would, is also here. We've already addressed this matter off record that it may not be in e-discovery for you.
And I'll stop by and look at it next week, Judge.
All righty. State and defense, you'll need to take that 1622 report into consideration if you continue negotiations on this matter, and maybe depending on the result of the trial, it may be necessary for us to be able to discuss that during adjudication or take that into consideration, okay?
No problem, Judge.
State. Court further admonishes that parties will exercise due diligence to ensure that discovery does not impede the execution of this trial on the 20th of June, the state set for it, 2022. Defense to exercise due diligence to notify defendant of the next court date, barring any motions that you may set for this matter. The next court date for this defendant will be the trial announcement on the 16th of June, 2022 for trial announcement. If between now and at that time, the defendant does accept the state's offer, defense will tender a motion, a jury waiver immediately and set this matter for a plea. And that being in the short range of it, that plea will need to take place before I release the jury. State, do you acknowledge the court's admonishment regarding the 1622 report and discovery notification of defendant, and if the defendant accepts the state's offer?
Yes, state acknowledges all of those.
Defense?
We acknowledge it, Judge.
Defense, do we have the email address for the defendant?
I do have it, Judge.
Okay, could you please go ahead and send that to the court coordinator so we can get a case setting form out to you and the defendant?
I will, Judge.
Alrighty, thank you. Will you be able to go ahead and get that done today? Tomorrow?
Yes, Judge.
Okay.
Today or tomorrow.
Oh, tomorrow is Saturday, so today?
Sure.
Yes, sir. All right, anything further on this matter? State?
Nothing further from the state.
Defense?
Nothing further from the defense, Your Honor.
But subject to your objections, the court understands that cause number 614051, State of Texas versus Autumn Faith B-Neck. This matter will be resolved by trial on the 20th of June 2022 with the trial announcement date of 16 June 2022. No interpreter is needed for this defendant. This defense will rely on the state's file and police report for witness lists. The arresting agency is the Bexar County Sheriff's Office. The state does not reserve its right to supplement regarding witnesses. All motions and pretrial requests will be in writing. Neither the defense nor the state has filed any motions in this case. Regarding discovery issues and concerns, the state does not see any. And the defense was mentioned concern regarding whether there are co-bans or body cam, and state has agreed to request all videos from Bexar County Sheriff's Office today, the 3rd of June, 2022. The defense has received their e-discovery and will check with the county clerk regarding the information, and also it is available in the court's file. Defense, with what you do have you been able to apprise this defendant of the nature of the offense and charges against her sufficient to waive arraignment?
Yes, Judge.
And do you waive arraignment on behalf of the defendant?
I do.
And the court has admonished the parties regarding the 1622 report that is associated with this defendant. The state has found this defendant and case to be eligible for pretrial diversion, proffered that offer to the defense. The defense has declined it. That offer was made orally. And so here we are to and the matter has been set for trial based on that declination. The defense will email the defendant's email address to the court coordinator today, the 3rd of June, 2022. State, any objections to court's recitation?
No objection, Judge.
Defense?
No objection, Your Honor.
All righty, thank you very much. Your excuse, I know the state does have to run, so we're off record on this matter. But Ms. Bianek, don't be late to my court again, okay? When you're scheduled for court, you need to be here and be here on time. So your next court date would be the 16th of June unless your attorney advises you of another court date. And ma'am, you need to be here on time. Thank you.
What time?
8:30, 8:25 a.m. Attorney Hayek?
You'll have a great weekend. Take care.
Yes, sir, you too. Thank you. Have a great weekend, sir. Your excuse. Attorney Hayek, the
I'm here,
state
Your
has
Honor.
a the state has a CLE, they've taken off to go to that CLE. So since I did not get the paperwork by the 1st of June, can you come back? They're willing to come back after their CLE is done around about 3:15. Can you and your client come back at that time?
Let me ask her. Is that okay? Can you get a hang of her, Judge?
Yeah. I mean,
Yeah, about 3:15, 3:30. Be glad to do that, Judge.
all righty. Thank you.
Thank you.
Yes, sir.